Hi, everyone. My name is Sara Shikhman, and I'm the managing partner of Lengea Law. At Lengea, we work with lots of healthcare businesses specializing in med spas, IV hydration businesses, regenerative medicine businesses, telemedicine platforms, weight loss, mental health, dental, and lots of different types of other healthcare businesses as well. We work with clients in many different states, and one of the states that we work in is Texas. And Texas has two pretty significant legal developments happening now. And this webinar is for our members to talk about two of the important laws that are going to be going into effect in Texas as of September 2025. And my colleague Nick Shafer, who's one of our Texas licensed attorneys, he's here and he's going to have a quick dialogue with me about these new laws. I'd love for you to introduce yourself and talk about a little bit about your experience and what you do and why some clients refer to you as their guardian angel.
Oh, well, I always get a little embarrassed about that one, that particular review. But my name's Nick Shafer. I'm our Texas licensed attorney. I've been practicing healthcare law for about 7 years now, and I've been at Lengea since January of 2024, so about a year and a half. I have a wide range of experience across healthcare law, employment law, corporate law matters. But primarily, what I do now is just help med spas, IV hydration clinics, functional medicine clinics, the medical aesthetic clients that we work with here at Lengea, and small business entrepreneurs, and help them operate compliantly, get their businesses set up, do compliance checks, do legislative updates like this one, and then work with people as they decide it's time to sell their business and move on to the next step.
Awesome. Thank you. Well, I'm so glad that we're able to do this. And thank you so much for putting the outline together for our presentation today. So we're here to discuss two new Texas laws, HB 3749 and SB 1318. We're going to quiz you guys on them at the end. So make sure you remember these numbers. And we're going to talk about what the intentions of these laws are and how they aim to impact the industry and the fact that they are going into effect September 1st, 2025. So really soon. One of the main topics that we're going to cover is with these two new laws coming into effect, what are the main things that practices should do to ensure compliance? So maybe Nick, you could begin with talking about what these laws are. Let's assume someone doesn't know about them at all. Like, what would you say about them?
Yeah, so HB 3749, it's referred to as Jenifer's Law. And we'll start off with that one, which you might have heard as in kind of like the lead up to this legislative session. And as this bill was going through the legislative process, this bill was kind of referred to as the med spa killer, because when it originally came out, it was going to require on-site physicians. It was going to restrict the scope of practice of nurse practitioners and physician assistants who were delivering services in med spas and medical aesthetic practices. And the whole purpose of the law was to address a really sad patient death that we had up in the Dallas-Fort Worth area, where a woman named Jenifer Cleveland received a elective IV therapy treatment, went into cardiac arrest and died. And in the kind of aftermath of that, as they did their investigation, they found that there was an unlicensed person and actually a phlebotomist who was delivering those services. The medical director was an anesthesiologist who was remote but also unreachable. They didn't have standard operating protocols. There wasn't a good faith exam process, or it wasn't done for this patient. So there were a lot of errors and they were out of compliance with existing laws on the books. But there's been kind of expanded attention nationwide and in Texas on compliance in medical spas, physician oversight, physician delegation. So they came out with this really broad bill that was going to cause a lot of issues for a lot of med spas across the state. And through the legislative process, when it went through the committee, they came up with a significantly narrowed scope for the bill so that it only applies to what they call elective intravenous therapy. And the long and short of the bill is that it's going to limit who can administer elective IV therapy. So before, Texas physicians had the power to, within the scope of their medical judgment, determined that unlicensed persons, paramedics, licensed vocational nurses, phlebotomists had the experience and training necessary to provide these services. The legislature was very clear. I watched all of these committee hearings. I watched the debates that went on that they want to limit the people, the licensees who can administer these treatments, who the physician can delegate these treatments to RNs, PAs, and MPs, and no one else. So that is kind of the crux of Jenifer's law. The other requirements that are in there are basically just designating the elective IV therapy as a medical treatment, which it already was, and then requiring a good faith exam before a RN or anybody can administer this treatment, which was already a requirement. So really the main effect is just that who can administer it.
So we talked about the tragic event and how the scope of the law was narrowed. And then one of the specific implications of this new law is that IV hydration in Texas now is specifically designated as a medical treatment. So what do you think are the implications of that?
I think that it was already pretty clear under Texas law that IV therapy was a medical treatment. I think that the biggest thing that we're seeing here is that the legislature is taking notice of these services. We were kind of sitting in a gray area with the rise of telemedicine after COVID, the failure of the medical board and the nursing board to kind of adapt to the new way that healthcare is being delivered, where, Texas law has loopholes, it has gaps that allow for certain practices that might not be like the pinnacle of patient safety or like patient safety focused to happen in medical spas and IV hydration clinics. I think if you're following the laws on the books, you're probably performing things just as safely as you would under this new law. But I think that the most important thing is that there is a microscope on these services now. Each patient injury, it's going to cause further scrutiny. You might have seen there was a big John Oliver report on medical spas that was on HBO, kind of diving into some of these issues. I think you just need to be prepared and be adaptable. I don't think that there's going to be anything like the original scope of this bill where it was going to require on-site physicians at every med spa, but I think that certain practices could get reined in. And the name of the game is just going to be treating this more like a medical treatment, maybe more licensed providers involved or on site, and just be ready to adapt when these laws come down.
Yeah, and it's interesting because it's Texas is not unique, right, in this. It's not like it's a medical treatment in Texas, but in all other states, it's not medical. In most states, IV hydration is either explicitly now in the law says that it's medical, or
Mhm.
it's kind of implied that it's medical. So Texas is just following some of the other states that already had this. So if someone's operating a multi-state practice, Texas is not the only state that's doing this. So just make sure you check for every state that you're operating in, is IV hydration considered medical and what the implications of that are.
Yeah, and I mean, Texas isn't alone in legislating this session. There were laws passed in Arizona and Wisconsin, I think, and
Mhm.
there we're seeing more and more guidance. Ohio just issued really restrictive guidance on IV therapy. This is on in the national spotlight, so being in strict compliance with these rules is just going to benefit you from here on out.
Yeah, definitely. So the law mandates a pre-treatment assessment by at least an NP or a PA. And a lot of these treatments right now are being done same day or next day or on a walk-in basis. So how does that change the process now in terms of, let's say a client comes in and they're a new patient and let's say there's only an RN in the office. What happens now?
So hopefully this isn't going to change your process too much because if you were doing IV therapy, you should have already been doing good faith exams. This law doesn't take away the telemedicine option. So if there's just an RN in the practice, you can use one of the good faith exam telemedicine companies to provide that telemedicine service, have an NP or a PA do a virtual appointment, sign off on the treatment and the order, and then the RN can complete the treatment according to a standard operating protocol. So I think the legislators thought they were kind of reinventing the wheel or like doing something new here, but in reality, these were always medical treatments and they needed a good faith exam before treatment was provided anyway. Now it's just going to be extra important that you have that documented because, in my experience, that's what medical boards and nursing boards are looking for is whether that good faith exam happened. And it's just going to be more so now.
Right. And it either happened or it didn't. So
Yeah.
when there's a board investigation, one of the things they ask for is show us the evidence that the good faith exam happened in your documentation. So that means that before the treatment was administered, there would be a note or something from your prescriber that says, for this patient, I prescribe IV hydration and the following treatment. So it's a hard one to hide from if it wasn't done. And it's not something that could be done after the fact because that doesn't qualify for a good faith exam.
Yeah. And I think specificity is your friend as far as the treatments that or the IV recipes or cocktails that your patient is signed off on. Make sure that everything is listed on that good faith exam on that order because we have seen medical and nursing boards take issue with just kind of a general description of the treatment rather than specificity and dosage amounts.
Yeah, that's good advice. Okay, so there are some potential gray areas here within this law. I think that one is there's no definition of physician's office, but I think the law mentions that these things have to take place in a physician's office. So what do you think about that?
As an attorney, there, I mean, you read through the law, and y'all can do this too. There's a lot of undefined terms. There's a lot of terms that aren't defined elsewhere in the Texas code or in the administrative regulations. Physician's office, for example. Technically, our clients who are operating through an MSO, MSA structure and delivering services through a physician-owned professional entity, could that be a physician office? And, the way modern healthcare works is what is a physician office? Is it a primary care physician's office, a dermatologist's office, or is it just delivering services through a PLLC or a PC? We could make that argument. We could also make the argument that these services, it says the physician can delegate to or may delegate to physician assistants, RNs, or NPs. It doesn't say that they have to. So we can get really lawyer-like and into the details of the actual language, but each of those interpretations would essentially render the bill moot. It wouldn't really apply to very many people at all. So I take the position that like trying to find creative loopholes around this probably isn't the best course of action, depending on your risk tolerance or if you just don't have those providers on your staff right now or it doesn't work for your business, then we're going to be contacting the medical board to kind of ask for additional interpretations of some of those gray areas. They might say, we can't give you an interpretation on that, but we will ask and we will be monitoring kind of medical board actions and enforcement to see how they are interpreting these rules. But right now, I would probably say the plain language is only PAs, RNs, and NPs can administer it. I don't think like a standalone IV therapy business it will qualify as a physician office. Maybe it will, and we could certainly make that argument, but the cleanest way is to just be in compliance, is just comply with the letter of the law.
Yeah, definitely. I think sometimes what happens is there's this desire to save money starting up a business, which we understand, but you may save, $5,000, but at the end, if there's an investigation and they require you to restructure everything and bring yourself to compliance, that may be $25,000. So it's just a lot. It's a lot more
Yeah.
over the
And
first, year or two.
I know that we have clients who might be the business owner and they're an esthetician or an LVN and they were doing IV therapy and now that option has been taken away from them. You should schedule a call with us to kind of talk about the best way to move forward if you're in that situation. We have until September 1st to try to get some more clarity on that, but the best course of action if you want to continue delivering these services might be to bring in a part-time RN and schedule your IV therapy for the days that they are there. Or we can talk more about like what the relative risks are, or if a medical and board of investigation comes, what that looks like for you.
Yeah, that's great advice. One of our participants is asking, will the GFE for IV therapy be good for 1 year, or do we need to get a new GFE every time?
It'll still be good for 1 year. This is what they want to see, is that you're creating that initial practitioner or physician patient relationship, that the person is receiving an evaluation from a physician or someone with prescriptive authority, and that they have created a treatment plan and ordered those particular treatments for that person. It doesn't need to be every time. If it did, they would have needed to put that language directly in the bill. I don't know if the medical board is going to add additional regulations interpreting this law, but if they do, that might be something that they cover.
Yeah, I agree with you. In terms of existing practices to help them become compliant or more compliant before September 1st, any steps you suggest? I think them scheduling a call with us to walk through what they're doing now and us suggesting some ways to become more compliant is good. Is there any other best practice that you can think of?
Unfortunately, this one is pretty straightforward and there's not a lot of wiggle room. If you're delivering elective IV therapy without an RN or a PA or an MP, then I would definitely make sure that you are operating through that MSO structure, have that physician-owned entity involved so that at least we can kind of cite to that gray area on, this is a physician office, it's a physician-owned entity. The services are being delivered through a business owned by a physician. We should fit into that exception. But other than that, I think it's going to be getting an RN into your practice who can deliver the services.
Yeah, and another thing people could consider is having written protocols that your RN is following.
Yeah.
So having the right documentation in place, even if sometimes the doctor is not there or all the time the doctor is not there, having the RN work pursuant to first a good faith exam from an NP or PA, and then second, pursuant to written rules that they have to follow. So even after a good faith exam is done, there would be a rule that says, for example, no IV hydration is to be done on a patient who has certain types of cancer and things like that. If that's the rule that you want to have in your practice. So having those
Yeah.
kind of rules in place, do you think those make sense too?
Yeah, definitely, unless you have a physician in there or maybe an MP or a PA, I would definitely recommend that you have a IV hydration or vitamin therapy protocol that the person administering this is following. We have those protocols in our library, so if you don't have one right now, just reach out to us.
Perfect. All right, so let's move on to the new non-compete law that's going into effect September 1st, 2025. So the law is called SB 1318, and it significantly expands the types of healthcare professionals who are affected by this new restriction. And so it's interesting because this kind of regulation varies so much state to state. Whereas I think the IV hydration portion is pretty similar across many states where IV hydration is considered the practice of medicine and you need a good faith exam. Some states really say no to most non-compete agreements, and some states say most non-compete agreements are okay. So talk to us about Texas and what Texas has to say with this new law.
Yeah, I was kind of surprised that this bill passed. Texas is traditionally very pro-business. We have pretty loose restrictions on non-competes generally. But I think what Texas is running up against is a healthcare provider shortage. And they're seeing that it's not just physicians, it's NPs, RNs, dentists, especially in rural areas, but really Texas at large. So I wasn't surprised that they clarified some of the restrictions on physicians, because there was a lot being left up to interpretation by the courts there, like what's reasonable for a geographic scope, what's reasonable for a buyout. Those were existing rules that have just received some more specificity. But I was surprised by the expansion to dentists, PAs, NPs, and RNs. So now for non-competes, anything signed after September 1st, an employment agreement, it's going to have to be a maximum 5 mile geographic radius for the non-compete. There will have to be a buyout where the person can pay a certain amount of money to get out of the non-compete. That has to be specifically included in the language of the contract and in that restrictive covenant. They place a cap on that buyout. It can be no more than 1 year's salary. We're going to have to kind of experiment with what language we can use for hourly workers and for people who might have commissions or like productivity bonus structures where things vary from year to year. But as a business owner, you might want to like feel out the edges of where that cap is so that you can still have some control over your providers. So it is an interesting rule. As far as like its application to medical directors, it's not going to apply to medical director relationships. It only applies to physicians doing direct patient care. So if you have non-compete for your medical director, non-solicitation for your medical director, those will still apply. I think the biggest question is whether or not contracts with kind of evergreen renewal clauses, which we do a lot in our employment agreements, whether or not those that renew do that automatic renewal after September 1st will have to comply with the rule if that is considered a new, like a renewal of the contract that triggers these requirements. We're going to be doing some more research on that, but I think that it's probably going to trigger those requirements. So if you have employees, if you're a business owner and you have employees who their contract term's about to lapse, or you just want to kind of lock them into a longer term contract before that September 1st date, that would definitely be something to reach out to us about right now. Otherwise, we would also recommend if you have one of those evergreen clauses where it's renewing each year, get in touch with us because we might need to adjust the language so that it complies with this. So have a buyout clause, have a no more than a 5 mile geographic restriction.
And is there also a time restriction? Like it's only valid for up to, I think, 1 year?
Yeah, so you can't go past 1 year anymore, which getting over 1 year, especially for like RNs and even part-time employees, was kind of testing the limits as to what was reasonable before in Texas anyway, but now they have that bright line rule, no more than a year. It's unclear how this applies to people providing telemed. The language says that the limitation can only be 5 miles from the person's primary practice location. So we're going to see kind of how this is being interpreted as it gets implemented and as it gets challenged. But for people who are working in office, the geographic limitation is going to be that 5 mile radius.
Got it. So with the new buyout requirement, so let's say somebody's salary is $100,000 a year, they could theoretically, to the employer to protect themselves, could put in that the employee, if they want to breach the non-compete, they could just pay $100,000, their full salary, and then they can get out of it. So that's still, I would say, very protective to the employer, because that's
Yes.
a lot of money.
Yeah, I think that the larger issue is going to be like the geographic radius because we definitely did more than 5 miles pretty commonly, especially in rural areas. 5 miles is not very far, and like cities like Houston and Austin, 5 miles. If someone's outside of 5 miles, then they can be a world away. They can be in a completely different subdivision, but it is going to be the 5 miles in 1 year is going to be pretty restrictive.
So I think the message here is if you have employees in Texas, make sure to have your contracts reviewed and updated because the strictest interpretation of the law would be that with every renewal period, this new law would come into effect. So even if the contract was originally written 5 years ago, but it's been renewing, at its renewal after September 1st, it could trigger this law. And so it's better to revise the contract then than to have this ambiguity, because if your ambiguity gets challenged, it'll be much more expensive.
Yeah, it'll be more expensive, and depending upon the judge, the non-compete they could just deem it unenforceable. So maybe you're going to have lesser protections than you did originally under your contract, but if you get into compliance with this rule before September 1st, you help your enforceability, and you lower your costs.
Definitely. So to summarize, the new law has kind of like three components, right? So to someone who's not familiar with it at all, tell our listeners like what those components are.
Yeah. So if you are hiring an RN, PA, an MP, or a physician to do patient care services at your location, you can put a non-compete in their contract, meaning they cannot provide those same services at a competing business or open their own competing business within a certain geographic radius. Here, the law makes it clear that that geographic radius can no longer be more than 5 miles from your practice location. So, a 5 mile geographic radius, outside of that, they will be able to join a competitor. They will be able to open their own business. There's a 1 year limitation. So, you have that 5 mile geographic limitation in place. The non-compete can be in effect for 1 year after the contract is terminated. We used to do a year and a half, 2 years sometimes, but it's going to be limited to 1 year now. And third, that non-compete has to have a buyout provision, and it can't be any more than the person's annual salary. We can help out with the language on what that looks like if they have kind of a different compensation methodology, but in general, like the average of what they would earn in a typical year, you can't have a buyout that's more than that. So if you terminate them or they quit, the non-compete will be in effect. Can't compete within 5 miles for a year, but if they pay out the buyout to you, then they can compete directly right away.
So there are all these new limitations on non-competes in Texas. What can employers do to protect themselves still? Are there other types of agreements that we could work on to help people still be protected?
Yeah, I think having a strong non-solicitation to protect your patient base makes sense. So we include these in a lot of our agreements already. If you don't have one in there and you're going to be updating this to get in compliance with the law, we can definitely add a non-solicitation agreement to that, basically meaning that if the person leaves, they cannot contact your patients and ask them to go with them. It can be a little bit difficult to prove that that happened and to enforce it, but it's still a better protection than nothing. So we would do a strong non-solicitation provision. We would do strong confidentiality provisions to make sure that they are not taking any of your work product or proprietary information with them. We would want to make sure that they don't have any. The physicians it's harder, but with the other providers, we make sure that they don't have any ownership over the patient's medical records or patient lists. And then last, it's we are increasingly moving towards more of a carrot than a stick approach for retaining employees. So if you can do things to make the position more attractive, whether it's increased compensation or some sort of productivity bonus, certain increasing benefits or discounts on treatments, things that make this position more attractive so that they're less likely to leave for a competitor or try to start their own shop.
Yeah, and it's becoming increasingly competitive in terms of getting great people, and we see sometimes people rush the employment process and maybe hire people without any paperwork, without any contracts. And a lot of times that ends up being a mistake. And it's better to have even a short employment contract or a short offer letter, a short something, anything. Better is better than nothing. We have some clients now dealing with situations where like nothing was signed and it's really hard. So even though like, there's this new law and it is a little more restricted than the current state of affairs, it's still better to have the paperwork in place. So if you don't have anything and you have employees, today is the day to think about maybe you're going to start having them give them an employment contract, and in exchange, you're going to have to give them something new. So to have a new agreement with people, you're going to need to give them either a raise or more vacation days or whatever. So maybe let's talk a little bit about that. Like, can someone just randomly give an employee a new contract and then say, okay, you have to sign this or you're going to be terminated?
So no, you're going to have to give something of value in exchange. Now, maybe a reduced scope in the non-compete would satisfy that consideration, but generally you're looking at a raise, some sort of added benefit, something that is tangible that is inducing them to enter into the new contract. So maybe you don't want to do that for all of your employees, but for the people who have every med spa owner knows the injectors who are popular with their patients. Trying to get those people into a non-compete, non-solicitation to try to keep them around. Pairing that with like a raise or added benefits is a good way to kind of do both the carrot and the stick. You have legal protections to keep them from leaving, but also you are showing them that you see them as a valuable part of the team and worth investing in.
Yeah, I agree, definitely. Okay, so we talked about these two different laws that are going to affect September 1st, 2025. To summarize, what do you think are the key takeaways or the key changes people should think about making in their practice as a result of these laws, or the things that people should think about and talk to us about or their financial advisors about as it comes or as it relates to these laws?
Yeah, so for Jenifer's Law, HB 3749, if you're doing elective IV therapy and you have estheticians, LVNs, paramedics, EMTs providing those services, or just an unlicensed person, then you're going to be out of compliance on September 1st. I would make plans to add RNs. If that doesn't work for your business model or you need more time to make that work, I'd encourage you to get in touch with us so we can talk about how to kind of minimize that risk and what we can put in place to, if an investigation came, basically say we're doing as much as we can, or we think that there's a gray area and an exception here and we should fit into it. For the non-competes, review your employment agreements, see when they are going to terminate or renew. If you are planning on hiring somebody soon and you want to get them into a longer non-compete, sign that agreement before September 1st. If you are a healthcare provider on here and somebody's trying to get you to sign a contract, maybe wait. But I would recommend taking a look at your agreements. If you have questions about it, reach out to us. If you see that your agreement doesn't have some of these features and it has that automatic renewal, that evergreen contract renewal in the term, then definitely reach out to us and we can get you new language, advise you on what consideration you need to give your employee for them to sign that new agreement before September 1st.
If people remember just one thing from our webinar tonight, just one key message, what do you think that is?
I think it's just that this industry is in flux, and there is increased attention from the medical board, the nursing board, from the legislature. Like there are going to be more changes coming. The more that you are in the light side of the gray areas, the easier it's going to be for you to adapt. So have a good medical director, somebody who is available by phone when you need them. Get into compliance, have standard operating protocols, make sure that your GFE process is compliant, make sure that you have good informed consents. Hopefully you do, but if you have questions about it, reach out to us because I don't think this is the end of the legislation that's going to be targeting med spas. Functional medicine, I think, is going to come up in some of the legislative sessions in a couple of years. So definitely get into compliance on who's administering your IV hydration. But if you have questions or you feel like you've been kind of operating in a way that might be a little bit in a gray area, now is probably the time or in the next year to address that and make sure that you're in compliance.
Awesome, thank you. Well, thank you so much for sharing all this valuable and important information today about these new regulations. Really appreciate everyone's time on this webinar. And if you guys have any questions at all, feel free to reach out to us. Our website is lengealaw.com, and you could schedule a consultation, and we'd love to answer your questions. And if you have any questions about any of the things we covered in the webinar, reach out to us. You could always call, email, or text. And we hope that it was useful to you. And if you have any feedback to us, let us know as well. And we wish everyone a very good evening. Thanks, Nick.
All right. Thanks, y'all. Bye.
Bye.